Hello and welcome to Wednesday Live by Sobirov's Law Firm. My name is Rahmat Sobirov, and today joining me in the studio is my colleague and teammate Benjamin Wilhelm. Welcome, Ben.
Thank you so much, Rahmat.
Today we will be talking about one of the most important business immigration programs on the federal level, that is Significant Benefit Work Permit, or referred to as C11 Work Permit. Please note that whatever you hear in these live sessions or any content that you hear on social media by Sobirov's Law Firm is a general information only. It's not a legal advice. However, we use certain real life scenarios, legal cases, and so on, but it's not a legal opinion. Please get a legal opinion from your own lawyer or hire a Canadian immigration lawyer for that purpose. Ben, welcome again, and we will be talking about the old C11 world, the new C11 world. Can you give us a little bit of background of your role in the firm and a little bit about the C11 Work Permit as a whole?
Yeah, absolutely. So my role at the firm is focused on our post-submission efforts with our clients. So I largely deal with reconsiderations and resubmission requests for all sorts of applications. This includes the C11 that we'll be focusing on today, but it's not just limited to C11. My focus is on just making sure that we have some continued advocacy efforts for our clients and making sure that, if we do receive a refusal that we don't agree with or that we think is unfair, that, our clients still have someone by their side.
Excellent. So one of the main programs that we deal at Sobirov's Law Firm is C11, as you know. Now, can you tell us, for those who don't know C11 Work Permit, what is C11 Work Permit, and what should be remembered as one message if somebody wants to do business in Canada? Why C11?
For sure. So C11 is a very open-ended work permit that's geared towards either entrepreneurs or business owners. And there's a little bit of a difference between the two. But if you're an entrepreneur or a business owner and you're looking to set up a new business in Canada, some of the other programs have some problems with them. LMIA and ICT require or highly encourage a higher degree of establishment in Canada for the business. And sometimes it's just not really practical to do that before you come to Canada. So C11, if there's one kind of takeaway, is that it opens this door to kind of getting an initial work permit in Canada before you've had an extensive business established here.
I see. Can it be used for those who want to purchase a business in Canada rather than establishing from scratch?
Yes, absolutely. So you can purchase an existing business or start up a new one.
What happened to C11 last year?
So in November of last year, the IRCC added some additional information to the C11 program, basically. Prior to November, there were less guidelines, there were less clarifications about exactly what the IRCC is expecting from the C11 program. It's still, like I said, a very open-ended program compared to other programs, but they have added some additional information of what they're looking for. These can be things like clarifying that they want some sort of language abilities, but also clarifying that the amount that you invest is not necessarily the most important thing.
And also, let me retract a little bit. C11 can also be used by people in the arts sector, in athletics, and then there is an economic benefit too. So the government, even prior to November 2022, they included the economic benefit rather than cultural and athletic, right? Yeah. So that's how we approach in terms of entrepreneurs trying to do business in Canada. You can still use Significant Benefit Work Permit because your benefit could be economic in nature rather than arts and athletic and sports, right? So yeah, just to give a background about that. Okay. Now, in November last year, there were clarifications. Can you run us through what were those clarifications?
Yeah, I can run through the major ones. So I kind of alluded to this earlier, but the C11 work permit is appropriate for self-employed individuals or people who are entrepreneurs. What the IRCC has done is added a definition to both of those terms. So now it's not kind of a vague definition, they are two separate groups under this program. A self-employed owner is someone who is a little bit more active in their business. They are performing more of the day-to-day duties. Depending on their NOT code, they're going to be performing senior managerial duties often, but they're going to have a higher degree of involvement. Whereas an entrepreneur is mostly looking to invest in the business, quickly establish it, and then not have those similar day-to-day duties.
So if I understood it correctly, self-employed, as the word suggests, he is employed in the business and he is the owner of the business at the same time. He does daily activities in the business. But whereas entrepreneur is the one who establishes the business and let others run the business for him, right? He hires someone else outside of his family members, of course, and let the business be run by some other professionals or workers. Is that the correct understanding?
Yeah, that's absolutely it. Like the entrepreneur will still have important job responsibilities, but there'll be things like establishing kind of the plumbing of the business, hiring the right people, and things like that.
Okay, sounds good. Any other highlights that you can share from the November 2022 clarifications?
Yeah, absolutely. So another thing that they added was kind of a vague language requirement. So in a lot of other programs, especially the PR, the permanent residence programs, there are strict language requirements, right? For federal skilled worker, you have to have CLB-7. If you don't have CLB-7, you're ineligible. For this program, they didn't specify that you actually need to take an IELTS score or any of the official scores. They've really just said they want a demonstration of your language ability and haven't added anything additional to that. And we'll talk about kind of why they've left it open-ended a little bit later, I think.
Let me clarify. If you cannot demonstrate your language skills through official recognized testing systems, how would you prove your language capabilities?
Well, you can prove it through a bunch of different ways. The main focus, I think, behind the IRCC's kind of concern here is just making sure that your service or your product reaches Canadian consumers, right? And so as long as you're able to demonstrate that your business just won't have, the plumbing needed to reach Canadian consumers, but it actually you can deliver what you're offering through, maybe you hire someone, or maybe your business is a technology-oriented business where you actually don't need that many language skills or that advanced language skills. We can use things like that to, show the IRCC that your business is going to reach Canadian consumers, even if you don't have strong language skills. Okay.
And what else has been clarified by the policy changes?
So there's a big focus on evidence of significant benefits now. We're seeing an increase of the amount of evidence and the amount of things that the IRCC doesn't want us to just research, but actually wants us to show them via, a thing that you submit in the online portal. And so what we're really focusing on lately is making sure that everything that we say about the business is backed somehow. The applicant has a strong business plan, and we can point to the business plan to say they have researched their market well, they know what they're talking about. Here's the resume, here are reference letters with previous experience, this person's very qualified, and just showing them rather than telling them about the significant benefits.
Okay. And I know that the government gave a very good examples of what could be a significant and what could be not so significant in terms of application. Can you give us some example of that, or examples of from your practice of dealing with Sobirov's clients?
Well, the example that the IRCC gave us actually falls exactly into an example that we've dealt with here at Sobirov's.
Okay.
The example that the IRCC gave was that a convenience store in Toronto may not have significant benefits because of its location. I think that what they're saying is there's a lot of convenience stores nearby, and so maybe your contribution isn't as needed.
Contribution to the local economy.
To the local economy.
To the Toronto city economy, a little shop wouldn't make any significant benefit. Okay.
That's what the IRCC is saying, at least. I'm not sure if I agree with it. Our senior lawyer here, Firuza, told me, or discussed with me the analogy of where would you open a bike shop, somewhere where there are 100 bike shops or somewhere where there's only one. Yeah. Well, the place where there's only one bike shop, there might only be one bike shop because there's no demand for bikes there, right? Whereas if there are 100 bike shops in Toronto, well, people are buying bikes in Toronto. Like 100 businesses have enough clients to operate. I guess the point that I was kind of getting to is that depending on where your location is, the significant benefit might vary, right? So we've had a convenience store in Toronto that has received a little bit more resistance from the IRCC, right? We had to take it to reconsideration and kind of explain to them why this business is actually a little bit unique from the other convenience stores and how their location, is situated right beside a subway stop that, has a lot of commuters right now. And so, the business did have significant benefits that we could argue. However, we had a similar business, another convenience store that was located in Manitoba, received no problems from the IRCC whatsoever. Didn't have to take it to reconsideration. It was just approved.
In a way, do you agree they want businesses to go outside of metropolitan areas? Is that what do you feel about that?
Absolutely. And it's not just with the C11 program. The IRCC has a really strong focus on bringing applicants outside of major cities just through all of their programs. And so if we can kind of align this general goal of the IRCC with the C11 program, that's going to create a compelling application.
So the changes happened in November 2022. Since then, how your practice changed? What have you been dealing with in terms of changing the strategy of the client's application? How successful were you in terms of reconsideration? Can you run us through that?
The biggest challenge immediately was we kind of received a wave of new refusals with a little bit new language in these refusal letters. There was an increased focus on the applicant hasn't demonstrated evidence of significant benefits. Well, this is really broad and it's somewhat concerning because the IRCC added a language requirement, right? It might not be a strict language requirement, but before November 2022, there was no reference to a language requirement whatsoever. And so now applicants have kind of an increased duty to show this language requirement that when they submitted their application, they didn't have to.
Isn't it unfair to judge us with the new rules when we already submitted the application prior to November 2022?
I absolutely think it's unfair. And that's an argument that we run in pretty much all of these applications. Whenever we see an application that was submitted before November 2022 and that was rejected after November 2022, and the reason for refusals are pretty vague, I immediately suspect that the IRCC has kind of imposed these new standards retrospectively. Exactly, and they have. So they're viewing the old applications as requiring these new requirements.
Okay. So now you submitted several reconsideration or resubmissions. How successful were you in light of the new sets of rules, basically, by IRCC?
Yeah, well, for these changes, we actually added an additional step to our approach. Okay. Some of the cases we could identify right away as maybe needing some more support to meet the requirements. And so we looked through the files to see, what additional information could we request from the applicant that might help them out. A lot of the applicants could provide some additional information, and so we immediately sent that information to the IRCC, added a submission letter with it to explain the significance. And even before some of these decisions were refused, we were able to address the new changes in advance.
Okay.
Now, that wasn't always possible, right? Some decisions were refused the same week that these decisions or these changes were made, right?
Yeah.
And so that wasn't possible for every applicant just based on the timing of things.
Yeah.
For these applications, we had to take them to a reconsideration to start. And kind of address that, you need to at least give us some time to think about these new changes. It's unfair that you're providing us with a vague a vague reason for refusal that may be based on these new changes that the applicant didn't even have an opportunity to provide.
You received a refusal for C11, let's say. What are the steps you go through? Can you run us through those steps?
Yeah, absolutely. So it's not just me that's working on our reconsideration and refusal team. We have several workers that work with me. The first thing that we do is submit a request for the additional reasons of the IRCC. Some people may be familiar with the style that the IRCC provides their reasons. It's usually a fairly copy and paste document that has a pretty vague reason for refusal. You have to kind of read between the lines And sometimes the reason for refusal is so vague that it actually makes it a little bit hard to read between the lines. So what we do right away is submit a request for these additional reasons that are within the IRCC's internal system. We request them, and it usually takes a while to process. So while we're waiting for them to process, we'll submit a reconsideration request. We like to proceed based on the information that we have available to us in many cases. And just address it as best as we can. Sometimes it's easier to read between the lines, and sometimes it's a little bit harder. But in either case, we want to make sure that we're at least making an initial attempt to tell the officer, your decision doesn't reflect these facts because, or you haven't provided enough reasons because.
I see. So Ben, you said that you will get additional reasons. You will find out what were the main reasons and additional information. And you mentioned that you will obtain those. What is the name of that document that you get from the IRCC side, so that for the benefit of the audience, they understand that the template letter of refusal is not the real thing, right? It's just the facade of what had happened.
Yeah, so we do what's called an ATIP request. An ATIP is access to information privacy. It's for a bunch of different Government of Canada services.
Okay.
What we get is they're called GCMS notes.
Okay.
These are the internal notes that an officer makes in their system when they're coming to a decision.
Yeah.
It includes things like how the eligibility assessments occurred, or like when biomedicals were completed. But most importantly, it also includes a section that's a little bit more open-ended, where an officer can write their thoughts in. This is the section that I'm usually most interested in.
Yeah.
I want to see the underlying reasons why the officer has reached their decision. Saying an applicant doesn't have temporary intent isn't enough. The person ignored that the applicant has 10 years of experience in their home country. Like, they can easily get a job if they went back, but they haven't mentioned that. And so the officer needs to mention these factors that would, contradict their conclusion.
Yeah.
If I don't see an officer mention the factors that contradicts their conclusion, then that to me signals that this applicant might have been treated a little bit unfairly, right? The officer needs to at least acknowledge our side of the argument.
I see. And it needs to base his or her decision on the documents on the pieces of evidence we submitted with the package. Okay.
Yeah, absolutely.
I see. Now let's focus on 3 main points that you want to share with our audience with respect to the new rules of C11 Work Permit.
The number one lesson, and I discussed it a little bit earlier, is that location is so important. I cannot stress how important your location is. For applicants who choose to move to Manitoba, the exact same business might have significant benefits in Manitoba. Same amount of investment, same plan. You're obviously, have the same experience. But you might be instantly recognized, and your decision or your application might be approved in Manitoba, whereas it might take a lot longer or eventually be refused if it's in Toronto.
What you're trying to say, correct me if I'm wrong, is if you want to settle down in the main provinces, in the main cities like Toronto, Vancouver, Calgary, and others, you have to do extra. Like, you have to provide extra evidence why your business is significant, will make a significant contribution to the local economy of that location. So location, as our friends from the real estate industry mention all the time, location is important. What is the second message you want to give?
When coming up with your business plan and your plan to enter Canada, be realistic about your business. The IRCC has clarified that there isn't a specific investment amount. The focus for C11 is broader than that. The focus is on significant benefits, right? It's not on you need $100,000 or else you can't come to Canada. It doesn't say that anywhere. And so we don't need to inflate your investment and make it unrealistic, because then that's something for the IRCC to pick at, right? If you say you're going to establish a business in Canada and in the first year you're going to reach 2 million in sales, well, you better have a good reason for it. Otherwise, the IRCC is going to say, you're an entrepreneur or a business owner. Aren't you supposed to be able to project this thing accurately? And so right away, I'd say, be realistic about the financials. And message number 3 is about that new language requirement. I think a lot of people are immediately kind of concerned with it because They didn't contemplate needing this, or maybe they don't have, like federal skilled worker needs CLB7, which is fairly high, right? And if you're at a temporary work permit, like, that's a lot of language skills to invest in Canada for a temporary work permit, right? But I think that the IRCC I know that the IRCC hasn't specified the exact level of language that you need. And what this tells me is that they're open to us, open to interpretation a little bit.
And how about those businesses that are catered towards certain ethnic groups or certain that require non-English language skills? For example, you want to target certain segment of the population in Canada that not necessarily talks in English or French.
Yeah, this is another reason that location is so important, because if we can show that where your business is going to be established is a location where there's a lot of people that speak, a language that you speak, well, you're going to be able to reach that market. You might actually have an advantage over someone who just speaks English.
So Ben, for the benefit of the audience, can you give us the latest examples of successful C11 applications in your practice?
We recently had success in a reconsideration of a client who was operating in the food and restaurant industry. The client's goal was to establish more of a chain of restaurants, kind of more like a franchise, but there were some problems with the application because of the IRCC's new focus on evidence, right? If the client wants to establish more locations, in the future, it's going to take some time to build 5 locations. Right now, what they can do is they can, build 1 or 2, right? They can't build 5 right away. Why would they build 5 locations when you haven't even allowed them to come into Canada, right? That's a lot of risk, and a lot of people won't have the risk tolerance for that, right? But that doesn't mean that that person didn't have a significant benefit. What we had to do was really emphasize to the IRCC that this person has the experience to build this business and to really expand it. They had, tons of success in the restaurant industry at their home country. They were looking to come with, their recipes and all of their experience. They were going to bring it here, and they were going to replicate their success story kind of in Canada, but in a format that was a little more suitable for the Canadian consumer, right? And so we just really need to show them that, this business plan, if they have anything near this, like anything similar to the success that they did in their home country, that they'll be able to build 5 locations.
So what would be a second example of successful C11 application?
We've had success with clients who are looking to import a unique product to Canada, right? Canada has specific products that have flaws in them that other countries have a product that, the problem solved in another country, but Canada just hasn't been introduced to that product. If you think that you have that sort of product in your home country and that Canada doesn't have it here, well, then that's a pretty unique service that you can provide, or a unique product that you can provide in this case. And then so we've had quite a bit of success with clients who are bringing in unique products like that.
I see.
In Canada, for these products, there's a lot of regulatory approval required. And so for this client, they had just started the regulatory approval process, but they hadn't concluded it yet. But by showing that we had evidence that they had started this process, they were able to have success with C11.
Excellent. And just for the record, C11 work permit is issued for 2 years, right? At the beginning.
A maximum of 2 years.
A maximum of 2 years. Okay. Well, thank you very much, Ben, for your time and insights about C11 changes and the last 6 months of practicing the new rules under C11 and clarifications. We look forward to talking to you again in 6 months from now, I guess. Those who are listening to us and they want to raise some issues in terms of what topics you want us to discuss at Sabirov's law firm channels, please let us know. And we look forward to hearing from you, your feedback, your comments. So stay tuned, subscribe, and share this information. I hope it was useful. Thank you, Ben.
Thanks, Rahman.
Thanks. Cheers.